So you've made an independent film and it's in the can, and you want to get it to the broadest audience possible. So you want to go for the Netflixes and the Hulus of the world. You want to get a theatrical release. You want to go for the whole 9 yards. And you know that to do that, you're probably going to need to work with a distributor. A lot of people ask me, how do I get my ducks in a row? How do I get my bases covered, and insert every other cliche, for that moment when I meet a distributor, for that pivotal moment when a distributor is interested in my film and they want to give me a term sheet and a contract and so on. And I don't want to totally embarrass myself with my lack of professionalism. Here's how, in my opinion, you can best get yourself ready for that moment of truth when you meet a distributor who's interested, at least from a legal perspective. Now, of course, you can't always anticipate the specific terms that a distributor is going to offer you in their term sheet or agreement. But there are some general rules, I think, about what a distributor is going to want, what they're going to ask you to provide in the contract that they give you. And those are the requirements that I'm going to be talking about in this video. Bear in mind that this presentation deals with issues of United States law. So if you're trying to get your film distributed outside the United States, that may present different legal issues than this presentation will cover. So let's get into some bases that you want to cover to make sure that you're in the best possible position to get distribution. First, make sure that everybody has a contract. Make sure that everyone, I mean everyone who worked on the film in any sense of the term, has a contract, whether it's your brother or your mother or your friend. The distributor, of course, doesn't know who your mother and brother and friend are. I'm sure that you trust them, but the distributor doesn't know if they can. And so they're going to want to make sure that the rights and responsibilities of both you and your mother or whoever the other party to the contract is are very clearly laid out in writing. And the reason for this is that they want to minimize the risk associated with distributing the film. They want to make sure that no one who worked on the film could potentially file a lawsuit and essentially put their whole investment that they're making in you and your marketing at risk, or even worse, in a really terrible situation, prevent the film from being released at all through litigation. For instance, there was a well-known litigation that resulted from people not having the proper contracts that had to do with the movie Malcolm X that was directed by Spike Lee. He was one of the writers, and he brought on this guy, Jeffrey Al-Muhammad, to consult with him about whether the film accurately represented Islamic beliefs, basically. And Al-Muhammad apparently rewrote a portion of the script to address that issue. But the problem was that Lee never had a contract with Al-Muhammad, and apparently he and Al-Muhammad never discussed how much Al-Muhammad was going to be paid. And of course, when the movie became a huge hit and it got nominated for Oscars and things like that, Al-Muhammad got upset because he wasn't getting a piece of the pie. And he sued Spike Lee and he sued the studio and claimed that his revisions that he made to the script made him a joint owner of the copyright in the script. And so he was entitled to a share of the profits. And of course, that ended up being a huge hassle for Spike Lee and for the studio. So don't end up in that kind of situation. The way you can prevent something like that, well, in that example, it would be if Spike Lee had signed a contract with Al-Muhammad that contained what's called a work for hire clause, saying that Al-Muhammad was only going to receive money in return for his contribution and would not receive any intellectual property right associated with the film, then that would have addressed that issue and they wouldn't have had to go through a big, expensive litigation. So the point is, make sure that you have a contract that spells out what the rights and responsibilities are of everybody who worked on your film. Second, make sure that everyone's contract has the necessary clauses. So everybody, as I said, who worked on the film should have a contract, but what should be in the contract? Here are a couple of particular clauses that a distributor is going to want at a minimum, just to make sure that you've got all of your legal bases covered in the contracts that you have with the people who worked on the film. Some distributors will even require this specifically in their contracts with you. The first is called a name, image, voice, and likeness clause. This means essentially that you can use the video and audio recordings that you've made of a person. Ideally, you want to say in this clause that you can use the video and audio recordings in any medium. So whether it's in the movie, in a trailer, in a poster, in a soundtrack album cover, in whatever medium, in whatever way that they're presented, you can do that. And you also want this clause to say that you can use the recordings anywhere throughout the universe. So anywhere in the world, and who knows, if we develop the ability to show movies on other planets, then you'll be able to do that there too. And finally, you want the clause to say, again, in an ideal world, that you have the right to use these recordings in perpetuity. That is forever. There's no time limit on your ability to display the recordings that you've made of them. This doesn't, of course, just apply to actors. This is a clause that you should have in the agreement with anyone who is going to be on the set of your film, including crew members, that assistant camera people and PAs and so forth, because you never know whether behind the scenes video or photos that you shoot are going to have those people in them. And you don't want them to suddenly object that, oh, no, I don't want to be shown in this BTS photo or something like that. And then you have to go through some sort of hassle and potentially pay them off in order to get this kind of agreement signed with them. I go into more details about common independent film contract clauses in a playlist that I have on this channel about that type of clause. So I recommend you checking that out. Next, we'll talk about a no injunctive relief clause. This says that a person who worked on your film can't get an order from a court, also known as an injunction, that prevents the film from being exhibited or distributed or something along those lines. Obviously, your distributor is going to want this because it would be catastrophic for the distributor to lose the entire value of their investment in the film if a court entered this type of order. Next, there's a work made for hire clause, like I talked about a little bit in the introduction in the Spike Lee example. This is a clause that says that whoever worked on your film only receives money in exchange for their contribution. They don't get any intellectual property rights, whether it be a copyright interest or a trademark interest or whatever. Your distributor is going to want this because they want to make sure that there's no dispute about who owns the copyright on your film, and again, stave off the possibility of expensive litigation about that type of issue. The next type of clause we'll talk about is a credit clause. In other words, this is a clause that makes clear what name someone is going to receive in the credits if they're going to be credited in the film, what position their name is going to appear in the credits, any restrictions on how their credits are to be depicted, and so forth. So, for instance, you might have an actor who has some clout who insists that they get their credit in the opening titles on a separate card, meaning that their name is shown on the screen and no other actors' names are shown on the screen at the time that theirs appears. Under normal circumstances, if the actor or whoever it is who worked on the film doesn't demand any restrictions on how they'll be credited, you want this type of clause to say that the production company has maximum possible discretion regarding how the credits will be displayed, so that no one can come back later and claim that they weren't properly credited for their work, which of course would potentially create a hassle for you and the distributor. So we've talked about some clauses. Obviously, that's not a completely exhaustive review of every type of clause that can be in a contract relating to someone who worked on an indie film. But I think that's sort of the core of what a distributor is going to want to see, because their main interest is going to be protecting themselves, as I've said, from any kind of liability. Next, let's talk about your credit and marketing commitments. One thing your distributor is almost definitely going to want to know is what kind of commitments you've made to people regarding how they'll appear in the credits and how they'll appear in any marketing materials relating to the film. By a credit commitment, I mean a commitment to credit a person in the opening or the ending titles. We talked about this in the example of an actor who wants their name to appear on a separate title card. Your distributor is probably going to want to ask for a list of the credit commitments that you've made and probably want to see any contracts that contain commitments of that nature. As far as marketing commitments, I mean a commitment that a person who worked on the film is going to appear in a certain way in the marketing materials, that is, in posters and soundtrack covers, action figures, and so forth. Suppose, for instance, that an actor has a clause in their contract saying that their image on the movie poster cannot be any smaller than the image of any other actor who appears on the movie poster. This is actually a common type of clause. This is what's known as a most favored nation clause. It basically says, I, the actor, am going to be treated just as well as the actor who is treated the best in this particular context. In this case, in terms of the size of the image of them that appears in the poster. And people do get very hung up on that sort of thing. Another example is organizations such as SAG, the Screen Actors Guild, or Breakdowns, the casting website. In their contracts with filmmakers, they often require that they be credited in the end titles and that their logos appear in the end titles. And if you've entered into a contract like that, your distributor is going to want to know that to make sure that they can meet all of the credit obligations that you've taken on. Because large teams of people usually work on films, even if it's a low budget or no budget indie film, from the cast to crew to producers, investors, music labels, accountants, lawyers, and so forth. It's a lot of people. So you may not necessarily remember all of the commitments that you've made to people regarding credits and marketing, and you want to make sure that you go back through your contracts, ideally in advance of having any kind of discussion with the distributor to make sure of what those commitments are and that the distributor can be informed about them. Next is getting all necessary licenses and permissions. So you want to make sure that you have a license to use any copyrighted material that appears in the film or material that's protected by any other intellectual property rights like trademarks. If you have music in the film that's not public domain, for instance, you're going to need to have a license to use it. How do you know whether a copyrighted work is no longer protected by the U.S. Copyright Act? In other words, whether it's become public domain. If it was created after 1978, the length of the copyright protection will last for 70 years after the end of the life of the author. So the likelihood that any kind of copyrighted work that you want to use in your film is going to still be protected by copyright today is fairly high, unless you're talking about, say, something that was clearly made in the 19th or the 18th century, like a classical music piece by Bach or Beethoven or something of that nature. I'll talk in more detail about the U.S. Copyright Act in an upcoming video. Anyway, the distributor is going to want to know about and potentially review all of your licenses, such as your music licenses, to make sure that it's not going to get sued by artists and record labels and other copyright holders. Your distributor will probably ask for something called a music cue sheet as well. For each cue or for each individual piece of music that's in the film, the document is going to show the title of the cue and its starting time code, its length, the composer and the publisher, and so on. I would suggest at least starting to pull that information together, because it's going to be a pain to have to do that under time pressure when you've been offered a contract by the distributor and the distributor is, pressing you about what you want to do and so forth. For the locations that you use in a film, make sure to get a license agreement that says, just as the contract that you would have with an actor would say, that you can use the image or the likeness of the location in your film. For example, if you film in a school somewhere, you want to make sure that there's no executive or bureaucrat at the school who can suddenly decide that you can't use the footage that you shot in the school anymore. In other words, that you can't use the image or the likeness of the school anymore. And they want you to edit them out of the film. Obviously, for a low or no budget indie film, that's going to be catastrophic. It's not like you can just up and, spend thousands more dollars bringing the crew to another location and reshoot whatever the scene was. So you want to have a clause in the contract with that school saying that you can use its image or likeness in the film for any purpose associated with the film. And then you take away the risk that the school is going to get cold feet about you using them in the film and then try to prevent you from doing that. If you are using TV and movie clips, which often are used in documentaries to give context, you want to make sure that you have licenses to use those clips, often from the broadcaster like a CBS or an NBC or something like that. Or you will have a good faith argument for why your use of those clips amounts to what's called fair use for copyright purposes. You've probably heard of this idea of fair use that allows you to get away with what would otherwise be copyright infringement. I'm going to do another video on what fair use means in depth, but for the purposes of this video about getting ready for distribution, I'll just say that distributors tend to be leery about using unlicensed video clips, even if the filmmaker believes that what they're doing is protected by fair use, because, as I've said, the distributors are paranoid about the possibility of getting sued and losing the value of their investment in the film. Another thing to consider when it comes to fair use is that the distributor is probably going to want you to get errors and omissions insurance, or E&O insurance, that applies when, among other things, third parties, such as copyright owners, are filing suit for alleged violations of their intellectual property rights. If you use unlicensed movie or TV clips in your film and claim that that's fair use, the insurer might require you to pay a higher premium than you otherwise would have because of the risk of liability for copyright infringement. Also, if you want to distribute your film in countries outside the United States, and particularly if you have a film clip or TV clip or something like that that originated outside the United States that you're trying to use without a license, the intellectual property laws in those countries may be different. They might not have the fair use doctrine under the U.S. Copyright Act. So all this is to say that relying on this notion of fair use, the idea that you're sort of transforming the context in which you present the clip and therefore it's okay, has a potential downside in the context of getting distribution. It's not impossible to rely on fair use if you're trying to get your film distributed, but it does present some possible downsides. Now, here's an intellectual property issue that indie filmmakers often lose too much sleep over, in my opinion. I think that it's actually not as serious a problem as they tend to make it out to be. And that issue is showing a popular brand or product logo in the film. A lot of times that's actually not violating the intellectual property rights of that brand. So for instance, say that a character in your film walks down the street and you can see in the shot that they're wearing Nike sneakers. Filmmakers sometimes come to me in a panic and they say, oh no, We didn't notice that this guy was wearing Nike sneakers at the time we shot this. Do we have to go back and shoot this entire scene where we're trucking along, watching this guy's feet as he walks? It's true that Nike's logo is trademarked, but the fact that it's trademarked is not enough by itself to allow Nike to successfully sue you for trademark infringement just for having a shot like that in the film. Instead, for Nike to show that you infringed its trademark, it would have to show what's called a likelihood of confusion, which means that the average person who looked at the depiction of the brand of Nike, in this case, in your film, would think that you had some sort of association with Nike, like that you were some sort of authorized representative of Nike. But the average person who sees someone walking down the street wearing Nike sneakers in the film is not going to believe that the filmmaker has some sort of official endorsement from Nike or is some sort of authorized Nike representative. Just as you wouldn't think if you saw a person who was walking down the street just in real life wearing Nike sneakers that they were like an authorized Nike representative and that Nike had asked them to do this or something like that, right? The idea is just as silly when it comes to film. So I wouldn't worry so much about this unless you are, going to make your own Nike commercial or something like that without Nike's authorization. I mean, but why would you want to do that anyway? Because you're not getting paid by Nike. So the possibility of getting sued by these giant brands, particularly if we're talking about small indie films that are not going to, be the next Avengers 5 or something like that in terms of their impact at the box office, I think it is not that much of a concern. That being said, always talk to a lawyer if you are concerned about the possibility of infringing some big brand's trademark because it pays to prevent yourself from having to pay significant legal fees if they do get upset. The next thing that you want to do is register the copyright in the film. In its contract with you, the distributor is almost always going to want you to give them a certificate of registration from the U.S. Copyright Office. Again, if we're talking about U.S.-based films, that says that your film has a registered copyright. The way that copyright law works, at least in the United States, is that your film is protected by the Copyright Act even before you register it, as soon as the film is completed. However, you can't file a lawsuit against someone for infringement of the copyright, let's say for using a clip or dialogue from your film without permission, unless you have that registration. And that's why it's important. To register your copyright with the Copyright Office, you're going to have to fill out a fairly simple form and pay a small fee. At the time of this video, if you wanted to register just one motion picture, you'd have to pay a $65 fee. And you'd also have to upload, say, a low-resolution video of the film to the Copyright Office's website. So it has what's known as a deposit or just a copy of the work. You can find out more about these requirements at copyright.gov. If the Copyright Office doesn't have any problems with your application or it doesn't need any clarification about anything you've said in your application, then it will fill out a certificate of registration and it'll mail it to you. It'll ordinarily take a month or two for the Copyright Office to do this. So if you submit your application now, it will help avoid any delays as you're negotiating with your potential distributor. And unfortunately, they always send everything by mail because being the government, they're locked in the 20th century still, and they can't adapt to modern conveniences like email. The next thing to do is to make sure that your production company is in good standing with the state. So you may have formed a limited liability company or some other type of corporate entity to produce the film. In fact, hopefully you're doing that and you're not just operating as a sole proprietor. You'll have a lot more credibility with not just distributors, but also investors and other people who may want to contribute money or some sort of assistance to the film if you have a limited liability company or some sort of corporation that is writing the checks and is signing the contracts and so forth. And it's not just you all by your lonesome. Also, generally speaking, if you form a corporation to serve as your production company and you've got them signing the checks and signing the contracts and so forth, the corporation is going to be liable for any unpaid debts that it may incur, but you're not going to be personally liable for them. Again, as a general matter, because of course, as in all things legal, there are exceptions to this rule. I'm going to make another video about what type of business entity it would be a good idea for you to set up, the various types of business entity, whether it's LLCs or C corporations or S corporations, and talk about the pros and cons of each option in a bit. So what do I mean when I say that your company needs to be in good standing with the state? What I mean is that you should make sure that before you are pursuing distribution for your film, your company has paid all of the taxes that it needs to pay to the state. It's filled out all the forms that it needs to fill out, and so forth. So let's say that you formed a limited liability company or an LLC to produce the film. In fact, that's how most production companies are organized, at least on the independent level. The paperwork and the fees that you have to provide to the state are going to depend on what state you're organized in, but there are a lot of similarities across the states. Let's say that you formed your LLC in California. If you did that, you're going to have to file a short form called a statement of information, which contains your company's contact information and the name of the members of the limited liability company. In other words, the owners, the name of any officers, such as a CEO and a CFO and so forth, and other basic information like that. You're going to have to file that within 90 days of first registering the company, and then every 2 years after that. Also in California, the LLC needs to pay a franchise tax of $800 a year. If you don't submit your paperwork and your taxes on time, then you run the risk that the state is going to forfeit or suspend your company's right to do business. And if that happens, it's going to be public information. So a distributor or an investor or someone who's looking up your company on the internet is going to be able to see that they have forfeited their right to do business within the state of California or whatever state they happen to be situated in. And of course, that's not going to lend itself to you successfully getting your deal done. So you want to make sure that before that sort of thing can happen, that you pay any back taxes and you file any overdue forms that you might have to file, or in the best case scenario, that you do those things on time. Because if you don't pay the tax on time or you don't file the forms on time, then you're almost certainly going to have to file a late fee to get your company reinstated in good standing. So those are the most important bases that I think you need to cover to get your film ready for distribution and to assure any sort of distributor that you may be working with that you are on the level, that you are a business professional that they can trust and that they want to work with. Of course, none of this is legal advice, because if I were going to give you legal advice, I'd have to understand your specific situation and your specific needs. This is just general information. And if you have any specific legal questions, you should always talk to a lawyer. So if you got something out of this video, I'd appreciate it if you'd like the video and subscribe to this channel so that I can get this kind of content out to more enterprising, independent creatives like you. Thank you.